All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Welcome to the Court of Appeals. I'm Judge Valerie Zachary. To my right is Judge John Arrowood, and to my left is Judge Fred Gore. To your right is our Deputy Clerk and our Officer Tom Salou from the Capitol Police. We have several things on the calendar this afternoon. The first is State v. Hines. Counsel ready to proceed? Have you reserved time for rebuttal?
Yes, Your Honor, I would request 5 minutes for rebuttal.
Is that taken care of? Great. Please proceed.
Thank you, Your Honor. Good afternoon. First, let me introduce myself. I'm Matthew Pruden. I represent the defendant appellant, Corey Hines. Mr. Hines was convicted of first-degree murder and firing a weapon into occupied property back in September of 2022, and he's currently serving a life sentence. Now, this case involved a 2-week trial, and based on that, there are obviously a lot of facts that come into play, but I'll try to be very brief and focus on the most pertinent facts. On December 11th, 2017, Deron Blanks drove a rental vehicle to a Happy Mart, which is a convenience store or gas station located in Whiteville. He parked in the parking lot of the gas station and sat there for a while. During the course of the evening, several people approached his vehicle, and eventually a gentleman named Elliot Dew approached his vehicle and entered the passenger side. Mr. Blanks and Mr. Dew sat there in the vehicle, and during that time, a Ford SUV drove through the parking lot, and shots were fired into the vehicle in which Mr. Blanks and Mr. Dew were sitting. Mr. Blanks was hit and had some injuries. Unfortunately, Mr. Dew was killed. Immediately after the shooting took place, Mr. Blanks quickly got rid of some items in his car to avoid police detection. There was a firearm, there was some ammunition. He also testified that there might have been drugs in there. Police came to the scene to investigate. Nobody that night identified who the shooter was.
Nobody that night identified, but later they did identify your client as a shooter, did they
So
not?
Mr. Blanks was the one person who identified Mr. Hines as the shooter. He did not initially, and in fact, during an initial interview with law enforcement, he did not identify a shooter. He said he didn't know who it was. Subsequently, he identified Mr. Hines. He mentioned somebody named Taquay Newkirk as being the driver, but later said that he assumed he was the driver. So that was basically the only evidence with regard to Mr. Hines being the shooter that night. Now, another big piece of this case was 404B evidence offered as 404B evidence that was offered at the beginning of the trial. And the state did this through its first few witnesses. It initially called Chantel Fulton, and she testified that on the night of November 26, 2017, roughly 2 weeks prior to the Happy Mart shooting, she was hanging out at Sawmill Apartments with Edward Shipman. They then went to Happy Mart, where she ran into Mr. Hines and Mr. Newkirk, who I mentioned earlier. They needed a ride, and she got Mr. Shipman to Mr. Shipman was the driver. She got him to give them a ride back to the Sawmill Apartments. They returned back to the Sawmill Apartments. Now, according to Ms. Fulton, once they got there, she saw Mr. Blanks pull up in his vehicle, and he pulled out a firearm. Shortly after that, or immediately after that, she heard some shooting, and she got out of there at that point.
Counsel,
Yes, sir.
not on the substantive, actual one-on-one facts. The challenge to the 404 is necessarily the credibility, not any procedural assisted ADA procedural issues. Am I making sure I'm understanding the proper challenge? You're not challenging there was any proper notice or anything to
That's correct, Your Honor. That's
all on the credibility piece and the admissibility.
That's correct, with regard to the 404B. And so, going back to what Ms. Fulton said, she got out of there and at that point after the shooting took place. She didn't testify. She testified she didn't necessarily see anything. The next witness was Edward Shipman. Mr. Shipman, his initial testimony corroborated what Ms. Fulton said. He took Mr. Hines and Mr. Newkirk back to the Sawmill Apartments. Now, he did not know them, so he referred to those people as her friends. But they went back to Sawmill. At that point, when they got back to Sawmill, he testified that a vehicle pulled up and he looked at his phone. And then he heard shots fired. And when he heard shots fired, he then ducked down. And he specifically testified that he did not see any shooters or any shooting. After that, he got out of his car when the shooting ended. It rolled down a hill, crashed into a small tree. He was able to get it and get out of the parking lot. Now, the state also called some witnesses, some law enforcement witnesses who testified about finding various shell casings at the two locations, the Happy Mart location and the Sawmill parking lot. So they found some shell casings and collected those. Eventually, those shell casings were given to Kelby Glass, who also testified at trial. He testified as a ballistics expert. And basically, the crux of his testimony was that he examined various shell casings, and he identified several of them as being shell casings fired from the same firearm. In other words, there were shell casings recovered from the Sawmill parking lot and from the Happy Mart parking lot that he said were fired from the same firearm. So that's really what I think are the most pertinent facts. So now I want to get into the issue.
There's pertinent fact that I assume you're not talking about is this video.
That's correct. So I wanted to get into the issues, and I'm glad you asked about that because that's actually the issue I wanted to start with. Obviously, there are a lot of issues, and the court can direct me to any issue that it wants to have addressed. But issue number 2 in the brief was the issue regarding the video. And going back to that, when the state called Edward Shipman as a witness, the state used Mr. Shipman to get a video into evidence. And what the video purportedly was a video of the Sawmill parking lot showing the shooting. So the state used Edward Shipman to get that in. Now, when the state introduced the video, the state claimed to be introducing that video for illustrative purposes. But there were a couple problems with that. So in order for a video to be introduced, to be offered into evidence for illustrative purposes, the video has to, the state needs to put a witness on the stand who can testify, with knowledge of the events that occurred in the video, who can testify that it fairly and accurately depicted the events that person observed. And this court has said, in, for instance, State v. Jones, that video surveillance, in particular, can be authenticated by a witness testifying that the video accurately depicted events that the witness had observed.
Now, in Jones, wasn't that the case where like 7 years had passed and the court was relying on other bad acts and those kinds of things? Wasn't that the crux of the Jones case?
That may, and what I wanted to point that out, at least in terms of what is required with the video here. So what we have in this case, as I mentioned, Mr. Shipman, he specifically testified he did not see the shooting. He did not see the shooters.
But
now,
he did identify his car, did he not, as being the car in the video, and he identified...
That's right. Now, the focus of the video here was the shooting. And this was clearly what the state was hoping to show in this video, the shooting that was taking place during this time. So he could certainly testify, hey, this is my car, and the state didn't have any interest in this. He could testify what his phone looked like because he was looking at his phone, or what it looked like below his dash or wherever he was ducking. But the state was focusing here on the video showing the shooting aspect of the video.
So to make sure, again, on this issue, we're not questioning or challenging the weight of it, but the admissibility of it to who they chose to.
The admissibility, and at least just in terms of weight, to the extent that it was prejudicial. But they chose to do this through Shipman, who was not somebody with knowledge of what happened. It was not somebody that actually observed these events. Now,
He
there's
was
also,
there and heard those events, though, right? And he testified that he heard those events, and he rolled out of the car and rolled down the hill because he thought he was going to get shot.
he testified that he heard it, but he did not see it. And that's an important part of the observation, particularly when he basically testified that he did not know what the other people in the car were doing or anything along those lines. So the state's focusing on what they're doing. They're focusing on the shooting, where they are, things along those lines. But again, this does nothing to illustrate his testimony because he offered no testimony about what was going on back there. Now, another issue with regard to that video being offered for illustrative purposes is the fact that, I say that video, it's really two videos. There were two videos that were purportedly of this parking lot, the Sawmill shooting, but from different angles. So the state, when it asked Mr. Shipman if he'd seen a video, he said he'd seen a video and that it fairly and accurately depicted the events. But then the state mentioned there being two videos. And he said, well, I only saw one video. And the state then said, well.
Did you just say that he said he testified that it accurately depicted what he saw?
He said that the state actually asked, I believe that the word the state used, did this fairly and accurately depict the shooting? And he did answer that. He did answer that, yes, it did, despite the fact that he didn't have knowledge of that.
Doesn't that go to the weight of his testimony and not the admissibility of it?
Well, it goes to the admissibility because, again, under the rules of evidence, under Rule 901B1, it's important that this comes through a witness with knowledge. And again, as this court has said, that this can be done in cases involving surveillance video when it's somebody who observed what happened. So when he's asked about this, he didn't observe these events that unfolded because he didn't see them. He was looking the opposite direction, or well, he was looking down. He was not looking at them, didn't see them, and testified that he didn't. And on top of that, again, he wasn't somebody with knowledge of everything that was going on around him.
I guess, counsel, could that be the splitting of hairs of whether the intent to have it admitted was for illustrative versus demonstrative? Obviously, he can't demonstrate happened that he didn't see, but obviously the other sense that he had was his hearing of how he shot. Repetitive. So I guess there's some questions that could be raised where he could testify to what he saw. Obviously, he didn't see everything, but he still could illustrate what he perceived. Does that not happen?
Well, I think the difference here with a video is that, and this is a video without sound, keep in mind. So what we have here when it comes to a video is something that shows images. It's showing what somebody would see. So we're not really talking about sound here or anything else along those lines. We're talking about what somebody could actually visually see here. And as the trial goes on, the state refers back to this video and the shooting and what people are doing while they're shooting and what people are wearing while they're shooting. The state even attempted to get one detective to identify Mr. Hines. Now, that was not allowed into evidence, but those are the things that the state really focused on with this video. But going back to another problem with regard to all this is that when the state mentioned that there were two videos here, Mr. Shipman said, well, wait, I only saw one video. And at that point, the state said, okay, well, let's remedy this. And the jury left the room. And it's hard to tell from the record exactly what was being shown. I guess it's safe to say that the video was being shown. We don't know how much or whatever. But afterwards, the state said, okay, did you see two videos? And Mr. Shipman said, yes, I saw two videos. But the state did not go back then and say, okay, now that you've seen two videos, did both of these videos fairly and accurately depict the events that occurred?
Excuse me, if the first video was properly authenticated, then where's the prejudice from the admission of the second if it's depicting the same scene but from a different angle?
Yeah, and obviously I'm arguing that it wasn't properly authenticated there, but with regard to this, when it comes to these videos, when it comes to the proponent of the video, they have to demonstrate that the video is what they claim it to be. So here, of course, the state claims this is, a video of the Sawmill shooting. They're claiming that it's that, but from a different angle. But we don't actually have a witness on the stand who says that yes, this fairly inaccurately depicts this shooting from another angle. So we don't know that it is what it is claimed to be. We don't know what video he was referring to when he said that he saw a video. And because they didn't go back and remedy that by saying, hey, does this fairly inaccurately depict both videos, we don't really know which video he was referring to there. So that's a problem there. Now, obviously, then you have the issue of okay, so this wasn't illustrative, it was a substantive, and it appears that the state was offering this for substantive purposes, but the problem here is that the state did not authenticate it properly for substantive purposes. In order to authenticate it properly for substantive purposes, it has to be shown that the recording process was reliable and that the video is the same video that was made during that recording process. There was never any questions asked regarding that whatsoever, not about the recording equipment or anything along those lines. So the state didn't properly authenticate it for substantive purposes either. So for all those reasons, the video should not have been admitted. It was not authenticated for any proper purpose that it could have been. And that video was a big deal. It's a video that, again, purportedly shows Mr. Hines firing shots in a parking lot.
But you will concede, would you not, that the trial judge did not let in the evidence that the state wanted to put in that it was Mr. Hines firing those shots?
That's correct. The state did not allow that in right there.
Judge did not allow that in evidence. So nobody testified that Mr. Hines was shooting that at that time, did they?
I'm sorry, testified?
Did anyone testify that Mr. Hines was the shooter in that video?
Yes. So,
to the jury?
To the jury. Mr. Blanks was the only witness who testified as to that. The other two witnesses who were present did not testify that Mr. Hines was a shooter at that point.
So Mr. Blanks, though, testified that Mr. Hines shot at him that day.
That's correct. He did testify to that.
But he wasn't testifying to that based upon this video. He was testifying to that based upon what he saw or purported to see. Isn't that correct?
That's correct. He was testifying as to that for that reason. So he was the only witness that offered that testimony. Without the video, you only have Mr. Blanks. I mentioned in the brief all the issues with Mr. Blanks' credibility.
Well, you also had the shell casings.
Yes, there are the shell casings as well. Now, when you look at this particular issue with regard to that, however, what it comes down to is, again, if you take that video itself out of the equation, all you have is Mr. Blanks testifying that Mr. Hines was the shooter on that particular date, November 26th, and then was the shooter later on at Sawmill. Now, if it's only Mr. Blanks testifying he's the shooter, we don't have this other corroborating evidence showing that these shell casings might have come from Mr. Hines' gun. Now, also keep in mind there were 3 shooters at Sawmill as well. There are multiple shooters. You have Blanks, Newkirk, and allegedly Mr. Hines. But what we have here is you take this video out of the equation. The jury looks at everything and says, okay, well, can we be sure that Mr. Hines was a shooter here? Can we take Mr. Blank's testimony at face value? And if the jury doesn't believe that Mr. Blanks is credible and perhaps Mr. Hines wasn't a shooter there, well, guess what? The value of those shell casings, they diminish significantly, because at that point, the jury, if they don't necessarily believe Mr. Blanks, they're not sure that those shell casings could have possibly come from Mr.
Now,
Hines.
is there any evidence that there was anyone else who was the shooter here other than Mr. Newkirk?
At the Sawmill shooting, during the Sawmill shooting?
Or either of these shootings?
Yeah, so as far as that goes, it's very, basically, if you believe Mr. Blanks, that it was Mr. Hines who was the shooter, again, he's the only witness who offers that. So other than that, we don't know. There was no evidence offered about other possibilities of who could have been a shooter. But for those reasons, the video should not have been admitted, and it was a big deal in this case, and it is something that prejudiced Mr. Hines' case. And again, the court can direct me to any particular issues. I'll move on to the third issue that was raised in the brief, which relates to the plea transcript, Mr. Newkirk's plea transcript that was presented against Mr. Hines. So the state called Detective Amy Corder to the stand, and through Ms. Corder, Detective Corder, they offered a plea transcript showing that Mr. Newkirk pled guilty to felon in possession of a firearm, firing a weapon into an occupied vehicle, and firing a weapon into an occupied dwelling. And all of that related to the incident that occurred on November 26th. In other words, it all related to the sawmill shooting. Now, our Supreme Court has held that evidence of a co-defendant's conviction or plea of guilty is not competent evidence against a defendant on trial. So in this case, what we get here is this guilty plea being offered against Mr. Hines, basically to prove his guilt in the sawmill shooting. And what happened in this case is that the state is connecting these two incidents. The state is connecting the sawmill shooting to the Happy Mart shooting. Now, Mr. Newkirk was not charged in the murder of Mr. Duke. But both Mr. Newkirk and Mr. Hines were charged together in the sawmill shooting. And here we have this evidence that our Supreme Court said is not competent to be used against the defendant to prove that he was involved in the sawmill shooting there. And again, that is being connected to the ultimate question of whether he was involved in the shooting that took place at Happy Mart. And it was the state's theory of the case that Mr. Newkirk was an accomplice during both of these incidents here. So what we have here is this being used in this case when it should not have. Now, the state, in its brief, mentioned that, well, you know, this only applies if the two co-defendants are facing the same charges. Well, I think that the rationale behind the rule is much broader than that. And as the Supreme Court said in State v. Campbell, a defendant's guilt must be determined solely on the basis of the evidence presented against him, and it is improper to make reference to the disposition of charges against the co-defendant. And I don't think we throw out that rule.
What you're asking is to broaden that rule, aren't you?
No, I think the rule is equally applicable. I don't think it broadens the rule. I think if it were not to be applied here, it would be a narrowing of that rule, basically. It just so happens that the cases where it became an issue before, the person whose plea was used happened to be a co-defendant in a case involving the same or at least similar charges. That was what happened in those cases. This is a different type of case, but again, it's the same rule. And that
Can you remind me in those cases what the direct evidence against the defendant was where this was also offered?
Yeah, so there were at least a couple cases involved. State v. Jackson and State v. Campbell were two of these cases. Now, as far as all the specific details, I don't have every detail right in front of me, other than to say that in those particular cases, it did involve certain crimes where the co-defendant whose plea was offered was at least involved as an accomplice in those crimes, whether or not they were facing the exact same charges. So that was a distinguishing factor in those cases compared to this case, where Mr. Newkirk was not charged with the same crime with regard to the murder. But again, here you have him as an accomplice.
Was Mr. Hines charged in the sawmill case?
Yes, he was. He was charged in the sawmill case as well.
Is it a difference? It makes a difference. This is in a completely different case without Mr. Newkirk?
I'm sorry.
Like now, you're talking about the sawmill shooting, right? You know, and now we have the Happy Mart shooting. Those are two distinct events.
They're distinct events, but they're also events that the state is connecting. And even if they are distinct events, again, that evidence of Mr. Newkirk's plea, it's being offered in this 404B evidence. It's a very huge piece of the state's case so that they can connect the two shootings, the sawmill and the Happy Mart shooting.
And that was a question I wanted to ask you about. You say it's a huge piece. So I want you to expand on that so you can convince me of how you get by harmless error if it was error to admit it.
Yeah, so as far as this being, now obviously the state, this is the first evidence the state puts out there. And what the state is, so the state's trying to connect this in a few different ways, but obviously going back to the shell casings, that's certainly a big part of it.
Well, but the shell casings have nothing to do with this plea transcript, does it?
No, they don't. Just going into sort of where the state's basically putting these together here. But what we basically have here is, now, obviously there's a lot of prejudice that is inherent in offering this type of evidence because it does, as the courts have basically said, it does create some irrebuttable evidence that the defendant actually committed the crime that the co-defendant pled to. But beyond that, by introducing this evidence here, this is basically evidence showing that Mr. Newkirk saying, hey, you know, I shot in these vehicles. There was no justification for it. Now, let's, again, take this out of the equation. Let's say this plea transcript doesn't come in. And let's say all the other evidence does. Obviously, I've argued against the video coming in, but right here, we have to just assume that everything else comes in. So if that comes in, the jury could see all of this. And without Mr. Newkirk's plea transcript there, the jury can really look at everything and try to figure out, okay, what was actually happening when this shooting took place? And one thing the jury could potentially see is when they look at it, if you look at the video, for example, you see Mr. Blanks pull up, and then you see shots fired back and forth. It's difficult to tell who exactly fires the shot first. Now, a jury could simply look at that, and they could say, okay, well, it looks like maybe Mr. Blanks was the first person who fired this shot. And if that's the case, then it's possible they could have been acting here in self-defense. That's important to consider because you have this whole theme during the case where the state's arguing that, hey, there's a motive here. Mr. Hines is after Mr. Blanks. He's trying to kill Mr. Blanks, and the motive is because he's trying to avenge his brother, Jawan Young's death. Now, if you take the plea transcript out of the equation, if the jury believes, well, this could possibly be self-defense right there, well, then it takes that motive off the table as well. So,
No, it doesn't take the motive off the table, does it? It just gives him a motive to go back and try to kill him for shooting at him.
But the state's also, when the state's connecting these things, they're sort of throwing the kitchen sink at it, but motive is one of the things that the state's arguing here. So the state's trying to say, hey, he's got this motive to kill the guy. Here's one example back at Sawmill, and this is why, this is why he did it at Happy Mart
I'm sorry,
2 weeks later.
we're cutting into your rebuttal time.
Thank you, Your Honor.
Thank you. Do you have further questions? Further questions? Counsel, you proceed.
Good afternoon. May it please the court. My name is Ben Zaney. I'm with the North Carolina Department of Justice, and I represent the state in this matter. Just to give the court a brief roadmap, I intend to argue in response to the issues that the appellant has argued so far in oral argument. However, I do think that I need to start with the general issue of 404B here in this case, just to establish what was, in the state's view, properly admitted here, because that speaks a lot to all the prejudice issues as they may arise in some of these other issues that come up. So, relying on defendant's account of the general facts here, you have a shooting at Happy Mart, which is the charged shooting. Mr. Blanks was in the driver's seat. The victim was in the passenger seat, Mr. Dew. Mr. Dew is killed in that shooting. At Sawmill, you have an extremely similar fact pattern where the defendant is shooting at Mr. Blanks while he's in his vehicle, in the driver's seat in his own vehicle. Both of these shootings occurred at night. Both of them are ambush-style shootings. And so there's sufficiently similar evidence here for them to be admissible under 404B generally. And as the state offered at trial, this evidence is indicative of motive, intent, plan, identity, an array of things that 404B is permissible for, not just one proper purpose. But one of the other things, and I added this in an MAA, asking forgiveness to the court last Friday, was that sometimes a proper purpose can also be if two crimes are so connected that that you can't really tell the story of one without telling the other. And that was in State versus Washington. This court decided that. And at trial, defendant's trial counsel effectively conceded that that was the case here. During the jury charge, or during the conference, the charge conference, this is at page 2006 of the transcript, the state suggests that there should be a 404B instruction to the court, and the instruction being 104.15, evidence of similar acts or crimes. And at that point, defendant's counsel suggests that the court continue looking on that instruction, and there it said that the instruction should not be given if in which proof of similar acts or crimes is offered where two crimes are so closely connected that either can be adequately proved without the other. And that was defendant's counsel's position at trial, was that these crimes are so adequately connected, so closely connected, that they couldn't be proved separate from one another. And so defendant asked the court to not give a limiting instruction under these circumstances. And under State v. Washington, that's another separate proper purpose, separate from the other purposes that the state was offering this evidence for. So that's the backdrop that this prior shooting is coming in under. It's being offered for all of those reasons. And so turning to the issues now that defendant has argued so far today, we have in his second issue about the video, as I believe, as he said, the state offered the video as illustrative evidence, and to do so, all they needed was someone with knowledge who could say that it fairly and accurately depicted what happened. And of course, a fair and accurate depiction can come from any of the five senses. It doesn't have to just be sight, as this court has alluded to in some of its questions.
Counsel, the issue that that was raised during the appellant's discussion is that the video didn't have any sound to it. So if we're relying on sight, which obviously the proponent that was testified didn't see everything, he obviously heard about it, and there's no audio from the video, what other senses are we relied upon to say that there was reliable correlation between the testimony and what was on the video?
Understanding, Your Honor, that the video doesn't have audio, but that doesn't mean that he can't remember the sounds of things that he's seeing on the video. And he describes being essentially in the middle of this firefight. He sees, his testimony describes exactly what the videos show, up to the point where the shooting starts, basically. And then he says he ducks his head down, which I think is an extremely natural reaction being in that scenario. And from that point, you can see in the video all these shots, which he would have heard. There's no way that he didn't hear that shooting. And so he's an eyewitness, so to speak, to that as well. And so to say that he can say that that video accurately depicts what he witnessed that night, even though, as my colleague on the other side has pointed out, he's ducking his testimony is that he ducked his head down during part of that shooting. And it would seem potentially crazy for an interpretation of this to be that witnesses must potentially put themselves in danger in order to witness something that is happening on video just to be able to authenticate the video later. Another issue is, in terms of common sense, is just that oftentimes these security footage perspectives are from perspectives that no human being was at the time. So the footage is naturally going to show, for example, if you have a security footage from a high up position, it's naturally going to show things that the witnesses involved in that scene didn't see from that same angle. And so at a certain point, we have to say that this was a person who was present in the scene and is able to say that, yes, this matches my recollection of what happened that day, and that has to be enough. And that's what Mr. Shipman does here. And then as to the two videos, the issue of the two videos, I just wanted to touch on that briefly. The state's position is that you don't even have to get to prejudice there. Mr. Shipman testifies that it was a fair and accurate depiction of the series of events. He does then say he thought it was only one video, but then after the court has him watch the videos there on a break with the jury out of the room. And so we know that he's seen both videos at that point based on the transcript of trial. And then the prosecutor asks him, sorry, just one second. The prosecutor asks him that he just testified that he saw two videos, right? Or something to that effect, and he gives an affirmative answer. And I think that can be taken as him saying, when he said that earlier, that all the evidence was fairly and accurately depicted in the video, that he meant that to mean both videos, not just one. So he gives an answer that's sort of retroactively saying, yes, I meant when I was talking about one video before, I was really talking about two. However, even if the court doesn't agree with that reading of the transcript, there's still the issue of these two videos are very similarly, the court can see for itself that these two videos are very similarly situated. They show the same events, especially with respect to defendant. I think it's fair to say that some of the left-right perspective is a little different, but overall, what's happening in center frame is the same in each. And so, if one is authenticated, it's difficult to see how a defendant could say that, or could show that the result would have been there was a likelihood of a different result, a reasonable probability of a different result, a reasonable likelihood of a different result, from the second one being introduced if the first one was properly authenticated.
Now, am I correct that the only instruction the court gave with respect to what we're talking about here is a photograph slash video was introduced into evidence in this case may be photograph slash video may be considered by you as evidence of facts it illustrates or shows. Is that the only, and I'm not sure I've got all the instructions on that, but is that the only instruction the court gave with respect to this video?
I believe so, Your Honor. I think you're referencing the part of the jury charge near the end of trial. I think the trial court, he or she, gave two instructions back to back. And I could be mistaken about that, Your Honor. One that pertained to video, one that pertained to photographs.
One, the court initially talked about maps, diagrams, and photographs, I believe.
Yes, sir.
And then talked about the video.
I think that is correct. I will say that, again, this could be encompassed in the state's request for a 404B instruction, which defendant said to the court should not be permitted, essentially, or didn't want the court to give. So it does fall under that purview where there could have been an additional instruction pertaining to 404B because, and again, I think that that's something that Your Honor talked about Jones before, that this case comes back to Jones in that same way. This video is evidence of 404B. It's not video that's evidence of the charged offense. And so to that extent, when you have all of this other 404B evidence coming in, that's the testimonies of Ms. Fulton, Mr. Shipman, and Mr. Blanks, at a minimum, you have those three things. This is at most just in addition to that, and as it pertains to 404B. And so in Jones, this court talked about how when the video's purpose is only to show motive or intent, and you already have all of this other evidence of that motive and intent and those other proper 404B purposes, then again, you don't have prejudice from the introduction of the video. So just touching on those things, and then finally talking about how the video was used later in trial. The video, as the court pointed out, or as the court asked my colleague on the other side, that the video was not used to identify the defendant in any way, shape, or form necessarily. The video was used to talk about sort of the investigative process of the investigators who did look at the video as part of their investigation. And they noted some similarities between what images showed of the defendant wearing earlier that day versus what the video showed him wearing the night of the shooting. But they weren't allowed to affirmatively identify him in front of the jury as part of that. So again, to the extent that the video is 404B, and I don't think the defendant has shown prejudice here. Turning then to issue 3, which had to do with the plea transcript. Again, this is 404B evidence. So at most, it is in addition to...
Well, let's assume that we disagree with the state's position as to whether or not this was properly admitted. I'd like to hear you address why it's not prejudicial if it wasn't properly admitted.
Understood, Your Honor. So in getting to that, I think that it's still 404B evidence, Your Honor. So as the court said in Jones, when you have a piece of 404B evidence that's being offered for, that's all that this could be offered for, it's showing Mr. Newkirk's involvement in the Sawmill shooting. Mr. Newkirk's not a charged co-defendant for the murder of Mr. Dew. So this is really this could only be offered to link in some way the defendant and Mr. Newkirk together for the Sawmill shooting. So again, that's just evidence of pertaining to 404B, Your Honor. And so...
Well, was there evidence that Mr. Newkirk was at the shooting that was actually charged here?
I think it's fair to say, Your Honor, that there could have been inference from some of the evidence that's offered by the state that Mr. Newkirk was involved. Mr. Blanks testified that he saw the defendant shooting at him from the rear of the vehicle, so someone else was driving. There was testimony from a state's witness that Mr. Newkirk and the defendant were hanging out together at her residence near the scene of the murder that night. And so there's evidence in the record that they were together that night, Your Honor. But I don't know that, I think that at one point Mr. Blanks had put Mr. Newkirk as the driver of the vehicle, and I can't, I'm sorry, Your Honor, remember if that was discussed in front of the jury or not. But at the end result of that discussion was that Mr. Newkirk Mr. Blanks backed away from that identification, as I recall, at trial. So there wasn't, I think it's fair to say that there was not strong evidence pointing to Mr. Newkirk at trial, but I think that there was some evidence where a jury might have thought about that, Your Honor. But I don't think that that was essential for the state's case in any way, shape, or form. The state was trying to defend it, and like I said, there was no evidence that Mr. Newkirk was charged with this offense presented in any way, shape, or form at his trial. Just another point relating to the plea, it also inherently does not necessarily prejudice the defendant in the sense that the defendant could have blamed Mr. Newkirk for what happened at Sawmill instead of, so in other words, the guilty plea in a way could have taken blame off of the defendant potentially, as opposed to, in other words, it's not inherently prejudicial. It could be prejudicial if framed a certain way, but it's not inherently prejudicial. It could be used to point the blame towards Mr. Newkirk. Also, in terms of how it fit with other evidence in terms of the shell casings, again, the shell casings only linked to a weapon from both to both crime scenes. That could have been Mr. Newkirk's weapons from the defendant's perspective at trial. And so based on that, the fact that this was offered, again, at most it's just additional evidence of motive, intent, plan, identity, all of these things that were discussed in issue 1 that the state believes is definitely sufficiently similar, definitely temporally approximate, survives 403 analysis as described in the brief. So based on all of that, I think that you have 404B evidence coming in of the Sawmill shooting. I don't think that there's any doubt of that. And this is not prejudicial in light of that, as a worst case scenario from the state's perspective. Those are my responses on the 2 issues that had been discussed so far. Before I sat down, I wanted to see if the court had any questions about any of the other issues.
I would like you to discuss with me a little bit more why, if we believe it was error for it to be admitted, why is it not prejudicial? What is the state's position for this transcript?
For the transcript of the plea, Your Honor?
Yes.
Again, it's because it's 404B only, Your Honor. And so it's evidence that Mr. Newkirk participated in a crime at the Sawmill Apartments. And so that isn't particularly prejudicial given that Mr. Newkirk's not charged in the charged offense here, and that there's plenty of other evidence indicating that the defendant was involved in the Sawmill Apartment shooting. So under those 2 general frameworks, it's not prejudicial, Your Honor. Not even to get into the fact that then the defendant could have pointed the finger at Mr. Newkirk for all of this had he chosen to at trial.
All right, we have no further questions.
Thank you, Your Honor.
So I do want to address some of the state's responses. First of all, the state mentioned, well, we don't have to put witnesses in danger in order for them to be witnesses who can testify that a video and fairly and accurately depicted something. And that's true. We don't have to put them in danger, but that's not simply the case here. For example, you can't just have somebody who hides away somewhere and doesn't actually observe an incident and say, hey, did all this stuff that happened here, is this showing what you saw, basically? And that's pretty much what was asked here.
The person was in the middle of the incident here, were they not?
He was in the middle, but again, when we're talking about a video that shows things that are visually occurring, he was not present for anything that could have been seen.
Is it your position that he would have had to have turned around and seen Mr. Hines and Mr. Newkirk shooting here, or seen Mr. Blank shooting here, and then looked back and forth in order to be able to authenticate this video? Is that your position?
Yes, it is my position that he would have to be at least in a position where he could see what was unfolding, that he could actually observe those things, because that is what the video, that's why it was offered. It was offered to show those things. Now, also getting into the point about identification, and again, the court did not allow Detective Porter to say, hey, that's Corey Hines in there. But it is important to note that the state, that the court did allow the state to get in testimony from Special Agent Witt, who testified as to items that Corey Hines was wearing in some photographs that happened to be taken that day. And he pointed out some, I believe they were white pants. And then the state went to the video and said, well, okay, what's this person in the video wearing? And you know, the detective is basically comparing it to that outfit that Corey Hines had on earlier, saying, hey, Corey, he's wearing similar clothes here to what Corey Hines was wearing in these photos earlier. So while that's not some direct identification saying this is Corey Hines, the state is certainly focusing on what Mr. Hines is doing in that video, who in that video happens to be Mr. Hines. These are things that the state's looking at, and these are the things that the state is doing when it's asking Special Agent Witt about that. Now, I'm going to shift over real quick to the plea transcript. And the state was talking about issues of prejudice and saying, well, you know, that plea transcript, you know what, certainly it could have allowed Mr. Hines to shift the blame over to Mr. Newkirk for that shooting. And you know, if the video were never shown, maybe that could be the case. But in the video, after that was shown, you can see multiple people firing shots. And if the jury's watching that video, again, potentially without that Newkirk transcript, they might come to a different conclusion as far as what happens there, rather than Mr. Hines being an aggressor or not having any justification for the shooting. And again, that goes into the whole theme of the case. It basically makes the situation where the state...
Now, but isn't it true that in this case, that at the mart where the murder occurred, there is eyewitness testimony that your client pulled up and fired several shots hitting this gentleman?
Only for Mr. Blanks. Only for Mr. Blanks.
But he did testify. He identified him directly, did he not?
He on the stand, he said it was Mr. Hines, but again, there were reasons to question that based on the multiple versions he had, based on the fact he was testifying pursuant to a leniency agreement, based on his lengthy criminal history, based on the fact he was trying to get rid of...
That's how,
weight.
yeah, that all goes to weight, correct?
I'm sorry?
Doesn't that all go to weight?
That, as far as that goes, as far as the weight of the evidence of Mr. Blanks identifying Mr. Hines as being the shooter there. That's correct.
All right.
Thank you.
Thank you very much. That concludes oral argument in this matter, and we'll take this under advisement. I want to thank you both for your excellent arguments today. Let's take a quick break. Yeah.